Our next story comes from the United States District Court for the District of Colorado, which deals with a person who was fired by a company because of comments they made in a public town hall kind of thing. And so we're going to read this and see what the court has to say about this issue and see if this goes better than the Florida one in terms of our agreement with the law. The pertinent facts are largely undisputed, and the court summarizes them here, elaborating as necessary in its analysis. Ms. Oransky was hired by Martin by MMM in September 2014 to work as a sales manager in its aggregated division. As part of her job duties, Ms. Oransky supervised sale employees who sold Triple M products and managed customer relationships. Among Triple M customers in the aggregate division is Arnalco Petroleum, a company engaged in oil and gas exploration and development. It uses Triple M's aggregate products to construct well pads, access roads, and so on. Ms. Oransky's duties call for her to have frequent contact with officials for further sale of products. Ms. Oransky resides with her family in Erie, Colorado. On September 27, 2017, the petroleum company hosted a community forum in Erie to discuss its plans for oil and gas development in the area. She attended the forum where she briefly met and chatted with an official with whom she was acquainted through her work. During the forum, Ms. Oransky, who was concerned about health and environmental consequences associated with oil and gas development, and others, protested the activities. Ms. Oransky led protesters in a series of call and response chants to the effect of, "We demand you leave our community," and "No drilling, no wells," among others. The protesters succeeded in causing the forum to be canceled early. After the protest, Ms. Oransky bragged in an online message that she helped to shut down the meeting. All the protest activities, as well as the aftermath, were recorded on video and posted on Facebook because, of course, they were. When reviewed the video of the activities, MMM became concerned that such activities might harm its business relationships. Within a few weeks of the protest, MMM terminated the employment for having taken actions inconsistent with her job duties and responsibilities, resulting in a conflict of interest with her roles at the company. So, all else being equal, our standard would be if it's a private company and it's at-will employment, they can dismiss you for pretty much any reason they want. But let's see if there is more beyond that as we read further. Ms. Oransky commenced this diversity action, asserting 3 claims of relief: violation of a statute which prohibits employers from discriminating against workers based on due to that employees engaging in any lawful activity off the premises of the employment during work hours. Okay, that sounds like something. And wrongful discharge and violation of public policy, that's not going to fly. And extreme and outrageous conduct, that's not going to fly. So her statutory element looks like it might have promise. Let's read on. So we have a standard review, which deals with entry of judgment when there's no trial necessary, no genuine issue of fact, so we're on summary judgment. There's no issue of fact. Great. Let's move on. The statute. The statute provides it shall be discrimination or unfair employment practice for an employer to terminate the employment of any employee due to that employee is engaging in any lawful activity off the premises of the employer during non-working hours. The statute provides certain exceptions, including where off-duty activities in question reasonably and rationally relate to the employment activities of the particular employee or particular group of employees, and where an action by the employer is necessary to avoid a conflict of interest with any responsibility the employee has to the employer in the appearance of such a conflict of interest. Well, to my mind, those strike me as pretty broad exemptions, all things considered, so I think we're going to squeeze into that pretty well. Let's read on. Ms. Oransky bears the initial burden to prove she's covered by the statute. That is, she must demonstrate that she was engaged in lawful activity during non-working hours and that she was terminated for the activity. The statutory exceptions are affirmative defenses on which she has proof. Fair enough. The motion first challenges whether Ms. Oransky can show her protest activities at the forum were lawful. Triple M argues that the disruption of the forum constituted a violation of Colorado state laws that prohibit a person from disrupting a lawful assembly by physical action, visible utterance, or other means, as well as provisions of the municipal code prohibiting or using any interference with a space within parks reserved for another person with a group permit. Okay, reasonable, but I still think she has the better end of it. What does the court say? Ms. Orsansky says that no citations were issued by the police as a result of the protest, and no one else was attempting to speak at the time when the protest occurred. Okay. In a prior case, the Colorado Supreme Court considered the meaning of lawful within the statute. In the case, the plaintiff engaged in the use of medical marijuana at home during off-work hours pursuant to state-issued license. When she failed a drug-administered test by her employer and terminated, she sued. The question considered by the court was whether the use of medical marijuana, a practice permitted by Colorado law but forbidden under federal law, constituted lawful activity within the purposes of the statute. The Supreme Court held that lawful is not restricted in any way and encompassed any applicable law, including state and federal law. Thus, the court upheld the dismissal on the grounds that the off-duty activities were not lawful. Okay, the court upheld dismissal of the statutory claim on the grounds that his off-duty activities were not lawful. So if they're unlawful for any purpose, they're unlawful for all purposes. Makes sense. The prior case effectively disposes of the contention that her conduct cannot be considered unlawful because she was not engaged in a crime. In the prior statute, there was no suggestion that the employee had been charged by federal authorities with possession. Indeed, the Supreme Court noted in a footnote, federal authorities had expressly indicated an unwillingness to enforce the law against this particular kind of person. Nevertheless, the Supreme Court concluded the use of marijuana was unlawful because it was nominally prohibited by a law, regardless of whether the law was actually being enforced. By the same reason, the question here is not whether a police officer actually cited, but whether an officer could have done so. That does seem like a reasonable question. I agree with that's a relevant question. In response to the motion, Ms. Orsansky offers a more extended argument as to why her conduct should be considered lawful, or at least why there's a genuine dispute as to whether it's lawful. Addressing the invocation of the statute, Ms. Orsansky concludes and argues that such a statute must be construed with a different case and argues there are at minimum factual disputes as to whether her conduct would violate the statute as construed. The statute provides any person commits disrupting a lawful assembly if, intending to disrupt any lawful meeting, possession, gathering, he significantly obstructs or interferes with the meeting, possession, or gathering by physical action, verbal utterance, or other means. The statute interprets the case interprets the statute in two significant respects. First, indicates that determining whether a person intended to disrupt a gathering, the fact finder must consider the nature of the meeting, that is, the implicit customs and usage of rules that are germane to the meeting, that is, outdoor events to tolerate more disruption than indoor ones, and political conventions might expect a prolonged, raucous, boisterous demonstrations where a funeral service were not, and to the extent the person was aware that his conduct was inconsistent with the customs of the assembly and whether they intended to disrupt the assembly significantly. And second, suggests that significant disruption should occur. And Tactical Bra says, this feels icky to me. I understand the logic. Getting fired for medical marijuana use is shitty. Well, I don't disagree with you that it is shitty. And we definitely could even go so far as to agree that it probably should be lawful. But, the question is, can they fire her for it? And apparently the answer is yes. So I agree that it feels icky, especially when Colorado says it's lawful, so it's a little bit like, With these standards in mind, the court finds there's no genuine dispute of fact as to whether Ms. Orsansky could have been cited for violation. There's no dispute the forum was being organized by Ordanco. It was held indoors in a community room and scheduled to run from 5 to 7. In publicizing the forum, Ordanco explained his purpose was to invite community members to meet the employees working on those planned activities, learn more about oil and natural gas, and ask any questions you might have. As such, implicit customs of such meetings might encompass heated exchange between individual residents and the representatives on a one-to-one basis, and perhaps protests and picketing outside the venue. But it'd be unreasonable to conclude that such meetings are customarily expected to target groups of 30 or more individuals holding up signs and chanting loudly so as to make other discussions between innocent residents and the Ordanco representatives impossible. And right here, I will just simply state on my own views, from standard First Amendment principles, I think that this is correct. I think that everyone has a freedom of speech, and my right stops where your right begins. So if they organized the space, they held this indoor space for their purposes, in my view, it's not consistent with the First Amendment for someone else to go in, and 30 of them, and go in and disrupt the meeting by chanting and singing and the rest. That's not proper. That's the heckler veto, and that's not proper. So I would say that that falls within the letter and spirit of the law in terms of disruption. It's not consistent with the First Amendment. And I agree with the court's note about picketing and protests outside. I'd have no objection to that, and I think that's perfectly fair within First Amendment grounds. So I think the court's analysis in terms of First Amendment principles is right on so far. It's also undisputed that Ms. Horsansky fully understood and expected her conduct would disrupt the meeting. In an email sent to protesters just hours before, she laid out her plans and expectations. She intended protesters initially enter the forum shortly before 6 and blend in with legitimate attendees. Everyone should look at displays asking general questions to reps to kill time. Do not protest at that time. Other protesters in the email chain, including Ms. Horsansky, also stated that they would sneak banners in the forum. Her email indicated at 6 she'd give the signal to the protesters, and they began chanting and displaying signs. Her email made clear that she understood and expected these actions would be disruptive enough that the protesters would be ejected from the forum. Likely, we will be asked to leave, which we should do. These facts underscore that she understood that her actions and those of the group she'd be leading would be unwelcome and would have the effect of disrupting it. Makes sense. The record is also undisputed the conduct did indeed significantly disrupt the forum. Approximately 2.5 minutes after the chanting, roughly at 6:02, a representative of the community center announced the facility was closing and everyone had to leave. She took credit for the announcement, immediately telling the videographer we closed it down. Ms. Ordansky is more demure in her response brief, arguing it's possible the closure was not related to her leading the chant inside the forum room, but rather a response to other protesters who were gathered in the hallway outside the building. But the record's clear that Ms. Ordansky was instrumental in the recruiting and instructing of those protesters as well. In September 17th email exchange, an individual named Teresa contacted Ms. Orsanska and asked if she'd like as many as 100 protesters from a Boulder-based organization to attend the protest, and she said, I'd be all for that. Another participant in the same email chain later advised Teresa that Polly, Ms. Orsanska, is going to advise the meeting in terms of any noise we need to make. We're going to trust Paul to take on this task. In her email on the day of the forum, she gave instructions both to the protesters that be inside and the people outside as well, who she said we will use as an important secondary event, almost as a diversion. In this sense, when Ms. Orsansky boasted we will close it down, it's clear she's referring to all the protesters she was directing, both inside and outside. Thus, even if she argues the forum was cut short because of protesters in the hallway, rather than as a result of her personal leading chants, it remains undisputed that she was responsible. Yep, sounds pretty much. Under such circumstances, the court finds there's no genuine disputed fact in the record, and on the undisputed facts, she conducted conduct that could have been deemed to violate the statute, and she cannot say that it was lawful. I tend to agree with that analysis. I think that's right on the money. Assuming that Ms. Horsansky could have established a genuine dispute as to whether it was lawful, the court would nevertheless enter summary judgment on a statutory claim based on the affirmative defenses. Statute allows an employee to restrict an employee's off-duty activities if those restrictions are reasonably and rationally related to the employment activities and responsibilities of a particular employee or group of employees rather than all the employees. Although there's limited case authority interpreting this exception, cases evaluating the statute as a whole recognize its purpose is to provide a shield to employees who engage in activities that are personally distasteful to the employee, but which are unrelated to the job duties. By contrast, off-duty activities that are non-direct conflict with the essential business operations could not be restricted. The court also explained under terms of the exception, such activities and responsibilities must be unique to or within the exclusive province of a particular employee or group of employees, as the exception allowed employees to retain certain high-profile members of staff from foregoing involvement in activities that would call into question their competence. Here, Ms. Orsansky's status as sales manager in the aggregate division is a job title that establishes unique responsibilities. Her job responsibilities include managing key accounts and contracts and overseeing development of customer relationships with customers, including the petroleum company. With regard to the petroleum company, Ms. Orsansky has been personally involved in offering the officials tickets to watch Denver Bronco games in the stadium box as a thank you for business, taking the officials to at least one lunch meeting, meeting with the officials to state her concerns, interceding with other units to resolve problems, leading the representatives on tour of facilities, and attending oil and gas industry representatives events as a representative of the company. Yeah, I have to concede the court's point. It does seem like she's pretty well involved here in a way that would taint the company. So, yeah, I think that exception probably applies. In that respect, Ms. Warsansky's close working relationship with the petroleum company distinguishes her job duties from other employees. If, for example, she was instead a heavy equipment operator in a quarry and her job duties simply entailed loading aggregate trucks, her leading protests against the protesters would present much less of a concern to the company, both because officials from the forum would be less likely to recognize the person they had never interacted with as an employee, and because the employment status as a role within the division would be far enough removed that it would be unlikely to jeopardize the willingness to continue as a customer. The same would be true if Orsansky was an anonymous accountant at the division or other high ranking official. As is evident from the job duties, by attending football games and oil industry presentations, ensuring good ongoing relations with large customers, it's indisputable an important job responsibility that extends beyond simply providing quality aggregate products, a function that is unique to her status as being a high ranking employee in a sales capacity. The only remaining question is whether a prohibition by the company that Ms. Orsansky not protest and alienate the aggregate customers is reasonably and rationally related to her unique job responsibilities. The court finds no reasonable fact finder could conclude otherwise on the fact of this case. Having company's primary point of contact with the customer leading a raucous presentation against the customer, demanding the customer leave our community can and should be expected to have negative repercussions on the customer's willingness to continue doing business with the company. As one might be expected, Ms. Orsansky's prominent role in leading the protesters at the forum caused immediate and adverse reactions within the company, and the record reflects internal emails among officials commenting that Ms. Orsansky's behavior warranted Ornaca looking for a change in vendor and that we're taking our business elsewhere. Internal exchanges between these officials made clear after learning of the events of the forum, some felt personally betrayed by the prior actions attempting to be helpful and friendly towards Ornaco. One referred to who as Two-Faced, and others felt like they felt dirty by having gone on a mine tour of the facilities that Ordansky had led for the representatives. This evidence made clear the belief that the behavior could harm the relationship with Ornaco was reasonably and rationally related to maintain good relations with the company. In the response brief, Orsansky first argues that because they justified terminating her as resulting from a conflict of interest, they may now not invoke the job duty exceptions. That argument mistakes the record. Although she's correct that certain officials only use the phrase conflict of interest when resulting in her termination, the own termination form states that employee took actions inconsistent with her job duties and responsibilities, creating a conflict of interest. Moreover, the court is not persuaded that the distinctions between job duties and conflicts of interest exceptions are so sharp and distinct that they could not assume reference that one precludes the other. So basically, not saying like, look, saying one is as good as the other in this case, and I tend to agree. There's not clear enough where they're disparate. Ms. Orsansky also argues that her job duties were all managerial, and even the task of developing customer relations is simply a duty to oversee relationships that are being developed. As discussed above, Ms. Orsansky's argument is inconsistent with the facts, which reveal that she was personally involved with developing and maintaining the relationship with the company by attending football games and oil industry conferences and leading tours and communicating with officials to resolve problems. She is far from an unseen manager, unknown to the company. In fact, her significant high-level involvement with the company is exactly why her decision to terminate is consistent with the provision. I would agree. Finally, she argues that construing the statute to favor M in these circumstances would require every M employee and other employees to refrain from any activity that might in any manner be critical of any of the 1,000 customers or potential customers of the employer. But that ignores the statute's requirement that the affirmative defense based on job responsibilities be limited to those situations where unique job responsibilities of a small group of employees impact the concern. As discussed above, only a few of the employees have job duties that involve maintaining good relations, and thus only a few of them could find their ability to engage restricted. For the vast majority of employees, and the vast majority of employees statewide, engaging in the same activities that she did would not exclude them from the protection of the statute. But based on her responsibilities and the particular overt way she chose to carry them out, the statute does not protect her. And therefore, it's liable to the judge defense. Very good. Okay, so that's basically the end of this case, because I think the other two are even weaker. So that was really the only good one in my view, and the court seems to agree because they denied her motion for summary judgment. So she loses her jobs, and that's the end of the case. So that's that. Yeah, I think it's a pretty interesting case. I have no problems with this. It seems like a perfectly reasonable reading of the law. So that's good.